Hey y'all, welcome back. This is going to be Unit 4B. We're going to be talking about hate speech. Sorry I'm so late on these lectures. It has been insanely busy this month, so I'm going to try to get all of these out today, and I apologize. Okay, so case one is RAV versus St. Paul, Minnesota in 1992. It is a unanimous 9-0 decision, and Justice Scalia delivers the majority opinion. So in 1990, some teenagers burned a cross in a black family's yard. They were charged under St. Paul's bias motivated crime ordinance, which states whoever places on public or private property a symbol, object, appellation, characterization, or graffiti, including but not limited to a burning cross or Nazi swastika, which one knows or has reasonable grounds to know arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender, commits disorderly conduct and shall be guilty of a misdemeanor. So these teenagers are charged under that statute, and they bring an appeal under First Amendment grounds. And the Supreme Court, basically rules for the teenagers. Um, they state, "We are bound by the construction given to it by the Minnesota court. Accordingly, we accept the Minnesota Supreme Court's authoritative statement that the ordinance reaches only those expressions that constitute, quote, fighting words within the meaning of Chaplinsky, assuming, arguendo, that all of the expression reached by the ordinance is prescribable under the, quote, fighting words doctrine. We nonetheless conclude that the ordinance is facially unconstitutional in that it prohibits otherwise permitted speech solely on the basis of the subjects the speech addresses." Okay, and then they go on and they say, applying these principles to the St. Paul Ordinance, we conclude that even as narrowly construed by the Minnesota Supreme Court, the ordinance is facially unconstitutional. Although the phrase in the ordinance arouses anger, alarm, or resentment in others, has been limited by the Minnesota Supreme Court's construction to reach only those symbols or displays that amount to fighting words, the remaining unmodified terms make clear that the ordinance applies only to fighting words that insult or provoke violence on the basis of race, color, creed, religion, or gender. Displays containing abusive invective, no matter how vicious or severe, are permissible unless they are addressed to one of the specified disfavored topics. Those who wish to use fighting words in connection with other ideas to express hostility, for example, on the basis of political affiliation, union membership, or homosexuality. So, maybe I'm, using fighting words against a Democrat or a Republican, Um, those aren't covered. The First Amendment does not permit St. Paul to impose special prohibitions on those speakers who express views on disfavored subjects. One must wholeheartedly agree with the Minnesota Supreme Court that it is the responsibility, even the obligation, of diverse communities to confront such notions in whatever form they appear. But the manner of that confrontation cannot consist of selective limitations upon speech. The point of the First Amendment is that the majority preferences must be expressed in some fashion other than silencing speech on the basis of its content. Okay, so they're saying, yeah, you can regulate fighting words, but you can't say, you know, only fighting words against women or blacks or Hispanics or whatever. Um, that's facially unconstitutional. You have to make it broad, right? All right. And then Justices White and Blackmun and O'Connor and Stevens sort of concur, but also mostly dissent. Excuse me. So I wanted to read this one sort of statement they made. They say, to avoid the result of its own analysis, the court suggests that fighting words are simply a mode of communication rather than a content-based category, and that the St. Paul Ordinance has not singled out a particularly objectionable mode of communication. Again, the majority confuses the issue. A prohibition on fighting words is not a time, place, or manner restriction. It is a ban on a class of speech that conveys an overriding message of personal injury and imminent violence, a message that is at its ugliest when directed against groups that have long been the targets of discrimination. Accordingly, the ordinance falls within the first exception of the majority's theory. Okay, so we'll get to what they're talking about here in a little while, but there is a strong sort of dissent. Okay, case 2, Wisconsin versus Mitchell. Again, this is a unanimous decision 9-0, and Chief Justice Rehnquist delivers the majority opinion. So Todd Mitchell is jailed for aggravated battery, and his penalty was enhanced because he chose his victim based on race. And the court wants to know, is this constitutional? So Todd Mitchell was jailed, and he brought First and 14th Amendment appeals. The court rules that the law is constitutional. Okay, so here's the context. Um, these young black kids watched a movie called Mississippi Burning, where a white man like just beats the shit out of this black kid, and I guess they're pretty hot about it. And so they see a young white boy walking down the street and basically call him out for being a white boy. And then he and his friends jump him, beat the shit out of him, steal his shoes, and the kid's in a coma. And so the Wisconsin arrests them and charges them with aggravated assault, which is a 2-year penalty. But if it's based on race, it becomes up to a 7-year penalty. And Wisconsin Supreme Court basically says, well, that's unconstitutional. You can't make the penalty worse just based on race. And their logic is, although the statute punishes criminal conduct, it enhances the maximum penalty for conduct motivated by a discriminatory point of view more severely than the same conduct engaged in for some other reason or for no reason at all. A defendant's abstract beliefs, however obnoxious to most people, may not be taken into consideration by a sentencing judge. So that's basically the Wisconsin Supreme Court ruling that you can't give him a maximum of 7 years. You have to give him just a regular aggravated assault charge. However, the Supreme Court disagrees. And they say, Mitchell argued that the Wisconsin penalty enhancement statute is invalid because it punishes the defendant's discriminatory motive or reasoning for acting. But motive plays the same role under the Wisconsin statute as it does under federal law, which we have previously upheld against constitutional challenges. Title VII of the Civil Rights Act of 1964, for example, makes it unlawful for an employer to discriminate against an employee because of such individual's race, color, religion, sex, or national origin. And more recently, in RAV, the case we just talked about, we cited Title VII as an example of permissible content-neutral regulation of conduct. So they're saying the state can actually moderate based on race sometimes. Moreover, the Wisconsin statute singles out for enhancement bias-inspired conduct because this conduct is thought to inflict greater individual and social harm. For example, according to the state and its amici briefs, bias-motivated crimes are more likely to provoke retaliatory assaults, inflict distinct emotional harms on their victims, and incite communal unrest. The state's desire to redress these perceived harms provides an adequate explanation for its penalty enhancement provision over and above mere disagreement with offenders' beliefs or biases. As Blackstone said long ago, it is but reasonable that, among crimes of different natures, those should be most severely punished which are the most destructive of the public safety and happiness. So they're saying because the state has an overwhelming social need to prevent these kind of race-based crimes, that it is constitutional to add this race-based um, addendum to violent crimes. Okay, final case, case 3 is a big one. Virginia v. Black in 2003. It's a weird ruling. It's a 7-2 decision, and Justice O'Connor delivers the majority opinion. And basic question here is Virginia's ban on burning crosses with an intention to intimidate a person or group of persons unconstitutional? And the court says yes, it is unconstitutional. And so here's what happened. There's a couple cases that all got rolled into this one appeal. The first case is a guy named Black. He is a member of a KKK group in Virginia. He got permission from a private landowner to hold a KKK rally on his land and to burn a cross on his land on private property. It was witnessed by some passersby and by a local sheriff, who then arrested him and they put him in jail. In another case, two white men are seeking to intimidate a Black neighbor who recently moved in, and they burned a cross in her front yard and were arrested again under this statute. Okay. And so O'Connor basically turns to the history of the Klan and of cross burnings, and she says there's this intricate link between the two, this very deep rooted linkage between the symbology of burning a cross and the KKK. And she says the history of violence associated with the Klan shows that the possibility of injury or death is not just hypothetical. The person who burns a cross directed at a particular person often is making a serious threat meant to coerce the victim to comply with the Klan's wishes unless the victim is willing to risk the wrath of the Klan. She goes on to say, the First Amendment permits restrictions upon the content of speech in a few limited areas. So there are restrictions, as we've talked about, which are, quote, of such slight social value as a step to truth, that any benefit may be derived from them is clearly outweighed by the social interest in order and morality. The First Amendment also permits a state to ban a, quote, true threat. And she defines a true threat. She says, true threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. The speaker need not actually intend to carry out the threat. Rather, a prohibition on true threats protects individuals from the fear of violence and from disruption that fear engenders, in addition to protecting people from the possibility that the threatened violence will occur. Intimidation, in the constitutionally prescribable sense of the word, is a type of true threat, where a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. Respondents do not contest that some cross burnings fit within this meaning of intimidating speech, and rightly so. The Supreme Court of Virginia relied on R.A.V. versus the City of St. Paul to conclude that once a statute discriminates on the basis of this type of content, the law is unconstitutional. We disagree. So they're kind of overturning R.A.V. in a sense. Virginia's statute does not run afoul of the First Amendment, insofar as it bans cross burning with intent to intimidate. Unlike the statute at issue in R.A.V., the Virginia statute does not single out for opprobrium only that speech directed toward one of the specified disfavored topics. It does not matter whether an individual burns a cross with intent to intimidate because of the victim's race, gender, religion, or because of the victim's political affiliation, union membership, or homosexuality, as quoted in the above case. The First Amendment permits Virginia to outlaw cross burnings done with the intent to intimidate because burning a cross is a particularly virulent form of intimidation. Instead of prohibiting all intimidating messages, Virginia may choose to regulate this subset of intimidating messages in light of cross burning's long and pernicious history as a signal of impending violence. Thus, just as a state may regulate only that obscenity which is the most obscene due to its prurient content, so too may a state choose to prohibit only those forms of intimidation that are most likely to inspire fear of bodily harm. A ban on cross burning carried out with the intent to intimidate is fully consistent with our holding in RAV and is proscribable under the First Amendment. Then they go on, however, and say, however, the prima facie evidence part of the statute is unconstitutional. The idea that just because you burned a statute, it is prima facie evidence that it was meant to intimidate. They say, it is apparent that the provision, as so interpreted, would create an unacceptable risk of the suppression of ideas. The act of burning a cross may mean that a person is engaging in constitutionally proscribable intimidation. But that act may mean only that the person is engaged in core political speech. The prima facie evidence provision of this statute blurs the line between these two meanings of a burning cross. As interpreted by the jury instruction, the provision chills constitutionally protected and political speech because of the possibility that a state will prosecute and potentially convict somebody engaging only in lawful political speech at the core of what the First Amendment is designed to protect. It may be true that a cross burning, even at a political rally, arouses a sense of anger or hatred among the vast majority of citizens who see a burning cross. But this sense of anger or hatred is not sufficient to ban all cross burnings. The prima facie evidence provision in this case ignores all of the contextual factors that are necessary to decide whether a particular cross burning is intended to intimidate. The First Amendment does not permit such a shortcut. So they're saying that yes, you can ban cross burnings meant to intimidate or cause fear of violence. However, there are cases wherein burning a cross can be just political speech, and those still have to be protected. So, Black, the KKK member who used private property to burn a cross, is released. The others, however, who burn the cross in their Black woman neighbor's yard are jailed, and their jailing remains. And so they have sort of a mixed opinion on this one. And then finally, Justice Thomas dissents, and he basically just says that all cross burnings should be interpreted as violent terrorist action and messages and should be banned regardless of context. So that's it. I will see you for the next section, which we will be talking about. I think the next section is speech on campuses, which, yeah, right now is absolutely wild. So, yep, speeches in colleges from page 476 to 491. So I'll see you for the next one. Have a great day. Bye.